हेलो एवरीवन, आप सबका मेरे चैनल लीगली पॉलिटिकल पे बहुत बहुत स्वागत है। और आज जो हम लोग डिस्कस करने वाले हैं वो है कुछ इम्पोर्टेंट पॉइंट्स एंड डिस्कशन ऑन ऑर्डर 7 रूल 11 ऑफ द सीपीसी विच डील्स विथ रिजेक्शन ऑफ द प्लेंट। तो इसमें हम लोग पार्टिकुलरली डिस्कस करेंगे शक्ति भोग फूड इंडस्ट्री लिमिटेड वर्सेस कैनरा बैंक ऑफ इंडिया एंड अनदर्स के केस में एक क्वेश्चन को डील किया गया था। उस चीज़ को हम लोग और डिस्कस करने वाले हैं। तो इसमें हम लोग सबसे पहले देखते हैं इस क्वेश्चन को, जो आपके स्क्रीन पे अभी शो हो रहा होगा कि वेदर द प्लेंट एज फाइल्ड बाय द अपीलेंट कुड हैव बीन रिजेक्टेड बाय इन्वोकिंग ऑर्डर 7 रूल 11 क्लॉज डी ऑफ सीपीसी। तो सबसे पहले हम लोग देख लेते हैं ऑर्डर 7 रूल 11 क्लॉज डी क्या कहता है। अब हम यहाँ पे आते हैं ऑर्डर 7 रूल 11 डी के बारे में। तो ये रहा ऑर्डर 7 रूल 11 डी, where the suit appears from the statement in the plaint to be barred by any law। तो ये ऑर्डर 711 क्लॉज डी का स्टेटमेंट है। अब हम लोग ऊपर चलते हैं, देखते हैं क्वेश्चन क्या है। वेदर द प्लेंट एज फाइल्ड बाय द अपीलेंट कुड हैव बीन रिजेक्टेड बाय इन्वोकिंग ऑर्डर 711 डी। तो इसमें हम देखते हैं कि कोर्ट ने कहा कि ऑर्डर 7 रूल 11 सीपीसी गिव्स एम्पल पावर टू द कोर्ट टू रिजेक्ट द प्लेंट if from the averments in the plaint it is evident that the suit is barred by any law of uh, any law including the law of limitation। so this the court then says this position is no more res integra, means it is not entirely new matter। we may usually refer to the decision of this court in Ram Prakash Gupta versus Rajiv Kumar Gupta in para 13 to 20। court had observed some points। तो first of all we will see when what are the cases in which the plaint can be rejected। first one is the where it does not disclose a cause of action। सेकेंड में बी क्लोज में देखते हैं where the relief claimed is undervalued and the plaintiff on being required by the court to correct the valuation within the time to be fixed by the court fails to do so, means where the suit is undervalued and in case if court has given time to fix that error and the plaintiff failed, then in that case also suit may be plaint may be liable to be rejected। we will see in C clause where the relief claimed is properly valued but plaint is written upon paper insufficiently stamped। Insufficient stamping of paper may also lead to rejection, and the plaintiff on being required by the court to supply the requisite stamp paper within the time to be fixed by the court fails to do so। And D clause is that where the suit appears from the statement in the plaint to be barred by any law। If the suit is barred by any law like limitation, then also it is liable to be rejected, which is the central point in this case that is discussed। Where it is not filed in duplicate is to be filed compulsorily, and F is whether the plaintiff fails to comply with the provision of Rule 9। Now there is another important case law, very important, Salem Bhai versus State of Maharashtra। It was held with reference to Order 7 Rule 11 of the Court that the relevant facts which need to be looked into for deciding an application thereunder are the averments in the plaint। The trial court can exercise the power at any stage of the suit। This is important। Trial court can do so at any stage of the suit, before registering the plaint or after issuing summons to the defendant, at any time before the conclusion of the trial, for the purpose of deciding an application under clause A and D of order rule 11 order 7. The averments in the plaints are germane. The pleas taken by the defendant in written statement would be wholly irrelevant at that stage. Another case is, wait, just a minute, I want to take something. Yes. This is also important case, Salem Bhai versus State of Maharashtra landmark type. And in this case, ITC Limited versus Debt Recovery Appellate Tribunal. It was held that the basic question to be decided while dealing with an application filed under Order 7 Rule 11 of the Code is whether a real cause of action has been set out. Real cause of action has been set out in the plaint, or something purely illusionary has been stated with a view to get out of Order 7 Rule 11 of the Code. See, and here in point 16, the trial court must remember that if on a meaningful, this case is very important, T. Arivanandam versus TV Satyapal, you can quote it in any of your answer relating to rejection of plaint. This is very important. You can quote as it is written here. The trial court must remember that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, that is cause of action, it should exercise its power under Order 7 Rule 11 of the CPC, taking care to see that the ground mentioned therein is fulfilled. If clever drafting, this is important, this is very philosophical and important line. If clever drafting has created the illusion of a cause of action, it has to be nipped in the bud at the first hearing by examining the party searchingly under Order 10 of the CPC. And it is a tried law that not any particular plea has to be considered. It is, and the whole plaint has to be read as observed by this court in Rooplal Saithi versus Nachattar Singh Gill. Only a part of the plaint cannot be rejected, and if no cause of action is disclosed, the plaint as a whole must be rejected. Means if there is any error in the plaint, and if it to be rejected, then it must not be rejected in part, but it must be rejected in whole. This is important point. It must be rejected in whole. Another case is that in Raptakos Bread and Coal Company Limited versus Ganesh Party, it was observed that the averments in the plaint as a whole have to be seen to find out whether clause D of Rule 11 Order 7 was applicable. And another is in Sopan Sukhdev Sabal versus Charity Commercial. This court held that there cannot be any compartmentalization. This line is also important. You can quote it in your answer. It will add grace to your answer. There cannot be any compartmentalization, dissection, segregation, and inversions of the language of various paragraphs in the plaint. If such a course is adopted, it would run counter to the cardinal canon of interpretation according to which a pleading has to be read as a whole to ascertain its true import. It is not permissible to call out a sentence or a passage and to read it out of the context in isolation. Although it is the substance and not merely the form that has to be looked. It is see this. It is the substance and not merely the form that has to be looked into. The pleading has to be construed as it stands without addition or subtraction or words or change of its apparent grammatical sense. The intention of the party concerned is to be gathered primarily from the tenor and terms of his pleadings taken as a whole. At the same time, it should be borne in mind that no pedantic approach should be adopted to defeat justice on hair-splitting technicalities. For our purpose, Clause D, we were discussing the Sakti Bhog case. For our purpose, Clause D is relevant. It makes it clear that if the plaint does not contain any necessary averments relating to limitation, the same is liable to be rejected. For the said purpose, it is the duty of a person who files such an application to satisfy the court that the plaint does not disclose how the same is in time. In order to answer the said question, it is incumbent on the part of the court to verify the entire plaint. Order 7 Rule 12 mandates where a plaint is rejected, the court has to record the order to that effect with reasons for such order. This is also important as court must cite the reason or record the reason why it has rejected the plaint. There are many more such discussions given in this case. So I have read all the I have explained some of that, and same idea is also uh, given in other paras also, this one. And so I have explained all the points that is necessary for order 7 and rule 11, in which this T. Arivanandam case is important. Salem Bhai versus State of Maharashtra is important. Their wordings are very important. You can directly quote in the answer. So this was the uh, topic of today. So if you understand and like the content, do share and subscribe, and also like the video for more such